Good morning, everyone, or whatever time of the day that this video finds you. Today's podcast would be a general overview of the component parts of a probate application. And I say general insofar as we understand that different jurisdictions have different nuances as to what goes into the application and how it's filed. So we are giving you a general overview of the probate application, what documents you need to put together and furnish your attorneys with the view to having an application filed on your behalf. So the first thing would be obviously a death certificate of the deceased. And I know in a number of jurisdictions right now, an application for a death certificate can be done online. So you would secure a certified copy of the death certificate of the deceased. You'd also provide the attorneys with the original will. And of course, in that will, it would obviously point to you being the named executor or executrix. So that would give you the locus to be making the said application. And of course, you would provide a copy of your birth certificate or some level of ID for you to confirm that the person named in the will is in fact you. So the probate application commences usually with a search being done of the probate registry. In some cases, like in Trinidad and Tobago, that registry is now online. So you submit a search, and that search obviously commences with the use of the death certificate, as I indicated earlier, for them to search the registry to indicate whether or not a will was in fact deposited there. In Trinidad, the depository of wills allows for persons to deposit their wills there, and or whether an application has been commenced in respect of that deceased. Once you get that search back and the search indicates that there are no probate applications in respect of the deceased estate, and there are no other will at the depository of the registry, depository of wills at the registry, then you can proceed to file the substantive application. Now, the substantive application normally includes an affidavit of the executor or executrix that has been named in the will. You would have to, as I said earlier, include a certified copy of the death certificate. You would have to attach the original will, and one of the witnesses, who would have been one of the two witnesses to the execution of the will by the deceased, would have to do an affidavit. It's called an affidavit of due execution, indicating that they would have seen the deceased sign the will on whatever date. They were personally present when the deceased would have signed the will. One of the other central components of an application would be the inventory, and that usually requires your attorney to write to several or to the financial institutions and or insurance companies to ascertain whether or not the deceased held accounts there or insurance policies there, and or conduct a search of the land registry, which in Trinidad can be done by way of a name search to see what properties the deceased would have been seized of as at the time of death, because all the information in relation to all those assets needs to be detailed in the inventory. That forms a very critical part of the application being made, because you would have to state the value of the estate. So in the inventory, we'll give a description of the property, the value of the property, which could include real estate, real property, cash in hand, cash in bank, shares, mutual funds, insurance policies, any other properties, which could include things like jewelry, furniture, appliances, household items. And then at the bottom of the inventory, you would have to indicate that that is the full value of, to the best of your knowledge, that's the full value of the estate of the deceased as at the time of death. And as I stated earlier as well, one of the witnesses would have to say they were personally present at whatever location when the deceased executed the will, because an affidavit of due execution is a requirement under the legislation for a probate application. Of course, you would file the requisite filing fees, and in the case of Trinidad, you would submit it virtually online, and in some other cases, you would be filing it manually at the registry, at which time the probate registry might either indicate to you that there are some queries, some need for additional information, some need for clarification. Once these queries are answered, then you would then give the probate registry some time to allow for the grant to be issued. And once the grant is in fact issued, then it allows the executrix or the executor to be able to distribute the assets of the deceased in keeping with the deceased instructions that would have been contained in the will. Now, I know a number of persons have indicated to me, listen, I find this probate process to be quite protracted. And some have also indicated that with in the jurisdictions where there are online filings that they found that the time has been significantly reduced. So we would be very curious to hear from your experience in terms of making applications, having applications filed on your behalf, the experience between the manual filings and the online filings, and just your general overview of how the process has flowed for you if you have, in fact, undertaken a probate application in respect of a deceased. So we thank you for tuning in, and we look forward to hearing your responses in respect of the topic for this podcast. Thank you, everyone, and enjoy the balance of your day.